Hello everyone, a very good morning to all of you. Welcome to the Officers Adda 24/7, the special session of your BRBL subject in the English medium language. Let's start the question and answer of your act. We are doing module D, in which the questions are as follows. So class, if we talk about the Partnership Act, so Partnership Act and SOGA Act was the part of your Indian Contract Act. Okay, now, so what is partnership? As you can easily see that class, partnership is basically the relation between person who have agreed to share the profit of lawful business carried by all or any of them acting for all. This is the definition of partnership. So if I say you in the ray diagram, suppose P1, P2, P3, these are the three partners. So what is the basic aim of the partner? The basic aim of partnership is whatever the profit that will come and whatever the loss, the profit will be distributed among all and the loss will be bear by all the person. So this is the basic aim of the partnership. Okay, it is the mutual relations of agency between the partner. Any partner can by his act bind all the partners of the firm. It means if one partner will do the wrongful act, for that wrongful act every partner will be liable. This is meaning of the business carried by all or any of them acting for all. So it means class C, P1, P2, P3. So partners are the agent of partnership firm. So whatever the work that is done on the behalf of partnership firms, partnership firm is liable, and whatever the work that is done by the partnership firm in the name of partners, the partners will be liable. So the mutual agency will be applied in both cases. Okay, now there are three types of what? Partnership. Partnership at will, partnership for a fixed period, and particular partnership. Three types of partnerships are there. Three types. The essential characteristic of partnership include its begin an association of two and more persons who enter into the agreement to carry on some business for the profit. It means the minimum number in the partnership is 2. The maximum is 50. Okay, and this number is written in your Company Act, not in Partnership Act. So this thing you have to remember. A LLP is a body corporate and a legal entity. So this is about your LLP. This is all about your LLP. So what exactly LLP? LLP is a body corporate and a legal entity separate from its partner. It has a perpetual succession, while LLP is a separate legal entity liable to the full extent of its asset. It means class, if we talk about the partnership. So partnership, full liability of the member. Okay, the partners are fully liable. So in LLP also, LLP is basically the combination of company plus partnership. The combination of company and partnership. Okay, so LLP basically you can see that legal entity separate from its partner. It has a perpetual succession, while LLP is a separate legal entity liable to the full extent of the asset, and the liability of the partner is limited. In this, the liability of LLP, that is limited because LLP is the combination of some features of partnership and some features of the company. That's it. Okay, so please see this class. I think this is clear to all of you. So today we have to finish the partnership important terms. Any doubt, class? Done? Now, every partner is bound to indemnify the firm for any loss caused to the partnership firm by his fraud in the conduct of the business. This means while doing the business in the Partnership Act, if any partner have done the wrongful act, for that wrongful act, the partnership firm is liable. Partners of a firm can decide their mutual rights and duties, change them from time to time with the consent of all the partner. It means whatever the decision that is taken in the partnership firm, okay, every partner have to give the mutual consent. The property of the firm. The property of the firm has held and used by the partner exclusively for the purpose of business. It means whatever the property is there of the partnership firm, the partners have to use that property only for the business of the partnership firm. These are some of the rights and duties amongst other which partner in a partnership have to observe their relationship in this, okay? And in the partnership deed, in the partnership deed class, every rights and duties are mentioned here. Every right and duties. In order to bind the firm, suppose if we want the partnership firm should be liable, the partner must do activities in the name of partnership firm and execute the document on the behalf of firm in any other manner expressing and implying the intention to bind the firm. It means if the partner is doing work, for that work, the partnership firm is liable. Every partner is liable jointly with all other partners and also severally for all the act of the firm done while he is a partner. So we can say the partner should be liable jointly and severally also. This is the core principle of partnership business. A partner in a firm has a certain implied authority which is not provided expressly in an agreement in writing otherwise. It means, class, if a partner do anything which is not written in the partnership deed, so in that case also the partner can do. The partner can execute the activity. Acts done by the partner under his implied authority with a certain exception subject to the certain condition bind the firm. It means if any partner will do the things which is not written in the partnership deed, for that thing also the partnership firm is liable. See, for that thing also the partnership firm is liable. Because it may be possible that it is done in emergency, etc. Okay. Done, guys? Now, each partner can represent the firm as per partnership deed, and the firm is liable to the act of such partners. That's it. The right of a partner can be restricted by partnership deed. Exactly. Suppose if the partnership deed means the document in which every right and duties of the partner is written. So if the partnership deed is restricting any person, any partner, that you do not have to this thing, so that partner should not have to do that act. If a third party has no knowledge about the restriction, then the firm will be liable for the act of each partner provided those done in the normal course of business. Exactly. Whatever the act which is done by the partner, just always keep remember the partnership firm is liable. Each partner is responsible jointly and personally for the act done on the behalf of the firm. If you just done the work on the behalf of the firm. However, in an emergency, a partner may do all act irrespective of express and implied authority to protect the firm from the law. It means in emergency, suppose the thing is not written in the partnership deed. So in that case, if partner is doing anything, the partnership firm is liable. That's it. So these are the things. Now, if we talk about the minor, we know that minor cannot enter into the contract, right? Minor cannot enter into the contract, but class, the minor can become a partner and he can just take only the benefit from the partnership firm. That's it. So minor cannot enter into contract. A contract with minor is void. A contract with minor is void. Since partnership is the relations resulting from contract, a minor cannot be partner in the firm. A minor can be admitted to the benefit of the partnership firm. This is important. What is this? A minor can be admitted to the benefit of partnership with the consent of all the other partners. This is done in a firm which already exists. Okay. And what is written here? Suppose a minor is there. Suppose a minor is there, right? And this is here. Minor become major. So when minor become major, so he have a 6 month. He have a 6 month of what? 6 month of right, 6 month of a time in which he have to declare whether he want to become a partner and whether he not want to become a partner. 6 month time. Suppose within 6 months, if he declare that he is a partner, then the liability will arise. And if he declare that he is not partner, so liability will be stopped. And in 6 months, suppose he say nothing, so he will become assumed as a partner. So this is your line that is written in this one. See, he cannot be full-fledged partner. After minor attain the majority, he has to decide within 6 months whether he continue or leave the partnership. Whichever be the decision taken, it gives rise to the different rights and responsibility of the person. Similarly, the retirement of partner or the insolvency of partner also give rise to certain rights and responsible for that thing. This is important one. This is important, guys. Okay. There is a provision in the statute for the dissolution of firm, but there is a distinction between dissolution of firm and reconstitution of partnership. What is dissolution? That is the ending of the partnership firm. A firm can be dissolved by agreement between the partners or by the court, or it gets compulsory dissolved in a certain circumstance and also on the happening of certain contingency. However, notwithstanding the dissolution, the partners continue to be liable to the third party for the act done by any of them before dissolution until public notice is given to them. This is important. Okay, if suppose any partner is going to be retired, so he have to give the public notice. If he will not give public notice, he will be still liable. That is written here. Okay, so this is your important points of partnership. And now let's do the question. Number 1 question. If one partner cheats a customer of a partnership firm, then all the partner of partnership firms are liable to compensate the customer. Tell me, guys, this is right or wrong? You have to just tell me the true and false. You have to tell me the true and false. If one partnership cheat a customer of the partnership firm, then all the partner is liable. That is true. Registration of firm is compulsory under Partnership Act. Registration? No. Registration is optional. So this is called false. It is compulsory to enter into the partnership deed. Yes, class. It is compulsory. It is compulsory to enter into the partnership, class. Tell me. The answer is absolutely no. Not compulsory. The partners are free to decide their mutual rights and liabilities. Yes, class. D. The partners are free to decide their mutual rights and liabilities. Exactly. Because they just make the partnership deed, so they have a right to make. This is true. A partnership deed can even provide that a particular partner would not take part in the day-to-day business decision of the partnership firm. That is true and false. E. Yes, class. The E one is, that is true. Okay, next. Consent of all the partner is necessary to change the nature of business carried on by the firm. Again, important. Yes, class. F. The consent of all the partner is absolutely true. A partnership at will can be dissolved by notice. Yes. G. Yes, class. A partnership at will can be dissolved by notice. At will, the answer is true. because the partnership at will, because there are three types of partnership: particular partnership, fixed partnership, and will. So by will, notice is only the requirement. LLP can be constituted as per provision of the LLP Act. This is totally false. Partnership can be arise out of the inheritance. Tell me, guys. That is false because it is made by the deed. The contract of partnership can be expressed and implied. The contract of partnership can be expressed and implied. That is true. Okay. Every partner has a right to receive the remuneration. Each line we have just read in the notes. Each line. So every partner have right to receive remuneration? The answer is no. Why, class? Because partner have to take only the profit. That's it. It is necessary that all the partners in the partnership firm must receive equal share in the profit of the partnership firm. That is true, guys. Tell me. It is necessary that all the partnership firm receive the equal share. The answer is false. Because it may be possible some partner is investing more, he will take the more profit. That's it. No partner is entitled to use the partnership property for his private purpose. That is true because every partner have to use the partnership for only for the business purpose. That's it. A single partner can be authorized to carry on business and sign the document on the behalf of the firm. That is good question. Each questions are important, guys. Each questions. Every partner is liable jointly with the other partner and also severally. That is true. We have just read it. Misapplication means taking property or money from a third party, using it for the purpose which is taken in the interest of partnership firm. That is true and false. Every questions are important, guys. Every questions. Misapplication means taking property or money from a third party and using it for the purpose which it was taken in the interest of partnership firm. This is absolutely wrong statement because misapplication, that is a wrongful act which is done by the partners. That's it. It is not for the interest of the partnership firm. So that's why it is false. When a person who is not at all partner in a firm either represent himself or knowingly permit himself to be represented as a partner. I think we have done it. This is called partner by holding out. P1, P3, 3 are partners we have read. Suppose E person entered, he is employee. P3 represent to X that E is also what? E is also a partner. So in that case, as you can easily see, holding out. Whatever we have committed, we cannot take back our words. True, false. Okay. First of all, just see. The partner can mutually agree and dissolve the firm. The partner can mutually agree and dissolve the firm. Yes, say yes or no. That is true. On the death of the partner, the partnership firm is compulsory dissolved. That is not true because it may be possible in the partnership deed it is written that if one partner will dead, we will continue the partnership firm. So that's why this is false. Now, this one. Tell me, guys. A minor can be partner in a partnership firm. That is absolutely wrong. Minor cannot become the partner. A minor can be admitted to the benefit of partnership firm. A minor can be admitted to the benefit of partnership firm. Yes, this is true. Minor is personally liable like other partners to pay the debt. No, minor will be never personally liable. The liability will be taken from the share of the minor. Minor who is admitted to the benefit of the partnership firm has a choice when he attains the majority as to whether he want to continue partner exactly that whatever we have written. Minor partner obtaining the majority has to give public notice within 15 days. This is absolutely false. Within 6 months, he have to give notice. Minor partner who has attained majority may give public notice to the effect whether he has elected to become. This is absolutely true. So I think class, we have covered everything of the Partnership Act, and you have just revised this Partnership Act.
A very good morning to all of you. Welcome to the Officers Adda 24/7, the special session of your BRBL subject in the English medium language. Okay, so guys, we are doing the summary of the act and the exam oriented questions. Okay, so now today's session, first of all, we will do the Transfer of Property Act, and then after we will do the Right to Information Act. Okay, so 2 acts we have to finish today. Done. Exam oriented questions. So what is TP Act? So now TP Act is basically, that is a transfer of property, the act by which living person conveys means transfer the property in present or in future to the one and more other living person and to himself and one and more other living person. So what exactly the TP Act is basically, suppose this X person is there, X person want to transfer the land to the Y person. So in that case, what will happen? X person will transfer the land to the Y person and Y person will give the money. So transfer of property should be done with the living person to the another living person. And X person can also transfer the property to himself also. Suppose X have a trust. Trust means a charity purpose. So in that case, he can also transfer the property. So this is exactly the transfer of property. Okay, now what is sale? Sale means basically a seller transfer the ownership of land to Nikita ma'am, and Nikita ma'am will pay the price money. This is called sale. What is mortgage? Mortgage is basically Y person transfer 5 lakh rupees to the X person, and X person, in that case, X person is giving immovable property as a security. Immovable property as a security to the Y person. This is called what? Mortgage. This is called mortgage. Okay, so in the mortgage, we always put immovable property as a security. What is actionable claim? Actionable claim is a claim to any debt, or you can say of unsecured debt. The claim that is made in unsecured debt, that is called actionable claim. This is called actionable claim class. That is much important. Okay, see, the claim other than the debt secured by mortgage, hypothecation, pledge. We know that in the mortgage, in pledge and in hypothecation, we just give the security, right? So actionable claim will not apply in these entity. Actionable claim will apply only in the unsecured debt. So this is the basic feature of transfer of property. Now let's do the question. TP Act basically contained provision relating to transfer of movable property and goods. That is true statement. That is true statement, class. Just tell me. That is very easy. That is very easy. Yes, that is true. That is false. Because TP Act always deal with the immovable property. Mortgage is the transfer of interest in a specific immovable property to secure the payment of money by the way of loan. That is true and false. This is the definition of mortgage. This is the definition of mortgage, and that is absolutely true. Okay, now class, the question is of types of mortgage. This is simple mortgage, mortgage by conditional sale, Usufructuary mortgage, English mortgage, mortgage by deposit of title deed, lease, etc. Now, come toward the question. In simple mortgage, the mortgager does not deliver possession of property to the mortgagee. That is true and false. If you just remember the simple mortgage, so simple mortgage is basically in which mortgager does not deliver the possession of property. This is true statement. In simple mortgage, suppose if mortgager not deliver or not refund back the loan, so the mortgagee have right to sell the property with the help of the court. Always keep remember this point. What is mortgage by conditional sale? Hanji class. What is mortgage by conditional sale? So mortgage by conditional sale is basically on the default of payment, the mortgage money on a certain date, the sale become absolute. Because in conditional, we just make a document, that is a mortgage deed, in which it is written, the mortgage deed will be automatically converted into the sale deed, right? So the sale become absolute, that is a true statement. That is the true statement, guys. Yes. Okay, that is a true statement. Next. In a usufructuary mortgage, the mortgager deliver possession of mortgage property to the mortgagee. That is true and false. Tell me. That is true and false. In a usufructuary mortgage, the mortgager deliver the possession of mortgage property. That is absolutely true. Yes. In the usufructuary, the mortgage deliver the possession. F. In English mortgage, the property is transferred absolutely by mortgager to the mortgagee with a condition to retransfer. If you remember the types of mortgage, then these points are, I think, very easy for you people. So, in an English mortgage, the property transferred absolutely by the mortgager to the mortgagee. This is absolutely true. In a mortgage by deposit of title deed, the property given as mortgage has to be situated in the notified town, because mortgage by deposit of title deed is also known as equitable mortgage. This is also known as equitable mortgage class. So that is false. Why class? Because it is not given that that who will notify that town, whether state government or central government. The right answer will be the state government, but it is not written. So that's why this statement is false. A lease from year to year and exceed 1 year can be made by transfer of possession or registered. We know that if a lease is year to year, okay, or any term exceeding 1 year, so the transfer is made by the register. So this is the false statement. Debtor has to given a notice of transfer of actionable claim. Debtor. Because in actionable claim, we know that the claim is only for the unsecured debt. So why should we give the notice? Because first thing is that we have not taken any security. And second thing, we will give you notice. No class. We will not give you notice. So the answer will be false. Okay, this is the right statement. Next, fill in the blanks. A lease for agriculture and manufacturing purpose can be terminated by lessor and lessee by giving 6 months or 15 days notice to the another. What will be the right answer? A lease for agriculture or manufacturing purpose, that is for the 6 month. This is the right state. 6 month is the right statement. Okay, now a memorandum recording mortgage by deposit of title deed does not require what? That is the equitable mortgage. Does not require registration or stamping. What is the right answer? The correct answer is class, that is registration. 6-month registration. Okay. The essential of a valid equitable mortgage are debt, deposit of title deed, intention as security or intention of safe deposit. Tell me guys. For the valid equitable debt, the deposit of title deed, that is intention of security. This. That is the right answer. In the case of accession means any increase to the mortgage property where mortgagee is in possession of mortgage property, the mortgagee is entitled or not entitled to the accession. Yes. So in the case of accession to the mortgage property where the mortgagee is in possession of mortgage property, the mortgagee is guys entitled. Okay. A mortgager while lawfully in possession of mortgage property shall have dash to make lease. Yes. Suppose in the mortgage we know that we cannot transfer the immovable property or we cannot physically hand over the property to the mortgagee. So the mortgager can lease the property also. The answer is yes, he have a power. Okay, he have a power, yes. Done? Okay. The power of sale without intervention of the court is given to the mortgagee in the case of equitable, English, simple, usufructuary mortgage. Tell me. The power of sale without intervention of the court has given to the mortgage in the case of, that is English mortgage. Okay, now the lease for an agriculture or manufacturing purpose is deemed to be the lease for year to year, month to month, week to week, yeah, infinite period. Tell me guys, second one. So in this case class, the lease for agriculture or manufacturing purpose is deemed to be the lease for, that is year to year. This is the right answer. Okay, so guys, in the mortgage, please focus on the, first of all, mortgage, sale, lease, actionable claim. So these are the 4 content and the 4 topics of your TP Act that is important. And in the mortgage guys, the types of mortgage is very important. The types of mortgage is very, very much important. Okay, next. Right to information. As we know that right to information, access to information under the control of public authority to the citizen. We know that we can ask the information from the public authority. The Act aims at promoting transparency and accountability in the working of every public authority and containing the corruption. Yes. This Act come into force on 15 June 2005, 12 October, this one. The Chief Public Information Officer and the Central Assistant Public Information Officer is appointed by the public authority. That can become in the form of question that who appointed Chief Public Information and Chief Assistant Public Information Officer. That's it. The central government constitute Central Information Commission and state government the State Information Commission. That is also important. That who appoint Central Information Commission, that is central government, and who appoint Chief Public Information Officer, that is the public authority. RTI is applicable to the bank also and other institution that is controlled by the government. That is controlled by the government. Okay. and RTI provide exemption. It means we cannot ask the question that disclose the information with respect to the certain information including commercial, confidence, trade secret. We cannot ask this one. And exemption is also available to the bank also. RTI give right to every citizen to seek information from any public authority under this act. Yes. He need not give reason for requesting the information. It means if Nikita ma'am is asking the question, so Nikita ma'am do not have to give reason that why I'm asking the question. No. Every public authority is required to display specified information about the organization, its employees, etc. Every public authority is required to designate one and more of its official as a central public information officer at the branch, district level, central assistant public information, etc. The central assistant public information officer are required to receive request for the information and forward same to the central public information. Yes, the assistant will always do work under the public information officer. That's it. Okay, next. Fees only 10 rupees we have to pay, and within 13 days the information should become. Okay, where the request involved disclosure of information furnished by the third party and the central public information intend to disclose it, he shall within 5 days from the receipt of request communicate in writing to the third party his intention to disclose. Okay, that is important. The act provide right to appeal to the officer of the senior in the rank of central public information officer. It means, class, suppose if we are not satisfied, we can just file the first appeal to the senior in rank of the central public information officer, right? And the further appeal is, this is the first appeal, and the second appeal is to the CIC. Okay, the first appeal, this one, lies within 30 days. Second appeal lies within 90 days. That is important. And CIC have to finish the decision within 30 days up to 45 days. That is important. Okay, that is important. Now let's do the question. Right to Information Act was enacted to contain corruption. Yes or no? Yes, that is true statement. That is true statement. RTI come into force on 12 October 2005. That is true. RTI 2005 repealed Freedom of Information Act 2002. I think right now we have done. Answer is yes. Right to information applies to all organization. That is not, because in the private organization we cannot ask any question. Central Public Information Officer is appointed by central government. Central Public Information Officer are appointed by central government. See, right now we have just done Central Public Information Officer. See, appointed by the Central Public Information, appointed by public authority. So that's why in this case there is a certain government. That is a false statement. So you can see that, class, how the questions are coming in the sessions. Right? So questions are very easy. Only you have to see the line-to-line things. Now, what is public authority? It means A option, authority established by government. B, authority established by law. C, a non-government organization. D, any authority and body or institution of self-government established or constituted by, under the Constitution, by any other law made by Parliament, by any other law made by state legislature, and the notification issued and order made by the appropriate government. So what is the right answer of public authority? So guys, the public authority 6-1, the right answer is D. Okay, now right to information means right to inspection of work, documents record, taking notes, extract certified copies of document and record, taking certified sample and material, all of the above obtaining information in the form of disk, floppy, these are items. So I think from today, this is this questions we will do it tomorrow. Okay, subject in the bilingual language. So class, we are doing the summary of the act and the exam oriented questions, right? So today we are going to do the LLP Act and Company Act. So first of all, let's understand the LLP. LLP is basically, it is the combination of Company plus Partnership Act. Okay, LLP is the combination of company and the provision of some partnership act. So now see what is written here in the paragraph. LLP is a body corporate with perpetual succession, existence of separate from the partners of the firm. That is called LLP. Right? Any individual, it means these are the qualities of company, the body corporate, perpetual succession, separate from the partners, etc. Any individual or body corporate may be partner in a LLP provided that they are competent to contract. They are competent to contract. So we can say individual can become the partner in LLP and body corporate can become the partner in LLP because they are competent to contract. That is plus 18, sound mind, not disqualified by law. Every LLP have at least 2 designated partners who are individual, not corporate body. Only individuals can become the designated partner. So in LLP, the minimum number is 2, maximum is unlimited. And 2 designated partner, minimum 2 designated partners should be made in the LLP. So this is the basic quality of LLP. Every designated partner of a LLP shall obtain designated partner identification number just like the director. Just like class, the director, because in the company we have read that in the company also the director need a director identification number. So same thing will be applied to the designated partner identification. The designated partner is responsible for all the doing of act, matter, things that is required to be done by the LLP. The LLP is incorporated once it is registered with the registrar. It means in LLP also registration is compulsory just like the company. Okay, so LLP is incorporated once it is registered with registrar and gives a certificate that LLP is incorporated by the name specified. On registration, LLP may by its name capable of suing and being sued. It means once it's get registered, we can file the case and LLP can also file the case. So this is the basic, the quality of LLP, guys. That is important. Okay. Next, these are the summary. The mutual rights and duties of partner of LLP and the mutual rights and duties of LLP. So this is of partners and this is LLP and its partner is governed by the LLP agreement. So this is very important that in LLP, the one of the most important document is LLP agreement. So the right and duties of LLP and the right and duties of partners are written in the LLP agreement. Is that okay? Because we have read in the partnership. In the partnership, the important thing is partnership deed. In company, the important document is MOA and AOA. Right? MOA and AOA. Okay? And in this one, we can say here, partnership agreement is there. LLP agreement is there. The rules regarding different conversion are provided in chapter 10 of section 55 to 58 of LLP, which has been dealt with in this unit beside the rules pertaining to maintenance of account. It means class, just like the company, the LLP also have to maintain the account, other records, etc. So basically, if I say that, it's contain the features of company. Okay. And ma'am and sir, if you are feeling any doubt, please ask the question. Okay, please ask the question. Now, question. The advantages of which form of business organization is incorporated in LLP? It means in the this one paid class we have done that partnership firm can convert into LLP, private company can be converted into company, and the unlisted public company can convert it into LLP. So just search in this option that where these words are written. Private company and public limited company, no. Sole proprietorship we have not done. Partnership firm we have done. Partnership firm and the private limited company, yes. C is the right answer because we have read this point. We have class read this point. Okay, next. True and false. LLP has perpetual succession just like company. Say yes or no. The answer is yes. Yes. Minimum number of designated partner is 5. Minimum. Minimum number of designated partner is 5. That is no. Minimum is 2. Under LLP Act, resident in India means person who has stayed in India for a period not less than 180 days during the immediate preceding year. 182. The answer is yes. An individual shall not become a designated partner in any LLP unless he has given his prior consent to such act. An individual shall not become a designated partner in LLP unless he has given his prior consent. The answer is yes, because the prior consent is required if any person is going to be designated partners. LLP may appoint a designated partner within 15 days of the vacancy arising for any reason. A LLP may appoint designated partners within 15 days of a vacancy arising for any reason. That is not the right answer. That is no. Okay, class? So these are the true and false, and every points we have already done. Every point we have already done in this session. Every point. Okay, it's over, class. So this is all about your LLP. This is, guys, all about your LLP. Now it's the time to study about the Company Act. It's the time to study about your Company Act. That is important. Okay, now see. First of all, the summary. Company is a artificial legal person which is created by law and can be dissolved by law alone. Right? It's an artificial legal person created by law, dissolved by the law alone. It is invisible, intangible, exists only in the eye of law. Yes, we know that. We know that the company have a distinct feature. A company can enter into contracts in its own name. Why? Because company have a separate legal existence. It can acquire, dispose property, can be fined under the provision of law for the violation of law. Exactly. Right? It is a distinct entity from the members forming it. Since a company is a distinct legal person, we know that it has a own signature, common seal with the name of company engraved in it. Consequently, it is also different from the partnership firm in the number of ways. Yes, we know that. We know that. Okay, so this is about your company. Now, class, we have read the various types of company, that is on the basis of incorporation, liability, on the basis of public interest, holding, subsidiary. So there are so many types of company that we have read. So many types of company, guys. Right? Now, The important document of company is Memorandum of Association and Article of Association. So these are the basic documents required by company prior to its incorporation has registered with the registrar of company. Yes. What is MOA? MOA give the basic details of company, its objective and the most important document for a company. And what is AOA? That is the important document of company, consists of a set of rules and regulations, bylaws made by company for the internal management. So the basic work of the basic document, that's OA, talks about internal management, and MOA its objective of the company, and the basic detail is given in the Memorandum of Association. Is that okay? Both MOA and AOA normally filed with the registrar of company before registration of company. That is important. And once registered, the effect of registration is that MOA and AOA bind the company to absorb all the provision of memorandum and article. It means the company have to follow whatever the things that is written in memorandum and the article of association. That's it. Okay. Now, what is doctrine of ultravirus, constructive notice, and indoor management? Everything we have just read. So if we talk about the ultravirus, it's laid down company cannot carry on the object not permitted by its memorandum of association. It means company cannot go beyond the rules and regulations. What is constructive notice? Every outsider is assumed to have read the memorandum and article of association. Exactly. Suppose if we have given the documents, whether the outsider read or not, it's none of company business. If the company have given, it is a right of outsider to read all the things. Indoor management laid down that outsiders are not required to see the compliance of internal regulations of the company. It means if the company have changed anything, so it's a company duty to tell the outsider. So indoor management is basically protect the outsider. Protect the outsider, and constructive notice protect the company. That's it. Protect the company. Now about the member class. Member of a company has been defined in section 2 clause 25 of the Company Act. Any person competent to contract can become the member of a company. Exactly. There are various modes by which company can acquire membership of the company. Yes, we have read. Every company is required by statute to keep updated register of members, debenture holders, etc. The register are to be kept in the register office and open to inspection by the general public. And we have seen the rights of company. Statutory rights, that is given in the Company Act. Documentary rights, the right which is given in MO and AOA. And property rights, that is the journal rights. That is the journal rights. Now, about some prospectus. What is prospectus? The public company has to issue prospectus. That is the simply brochure before raising fund from the public. The company, the promoters, directors of a company have certain liabilities for any wrongful statement that may be included in the prospectus on the basis of public invest funds into the company by the way of subscribing to the share and the debenture of the company. And suppose if any misstatement is done in the prospectus, so the civil and criminal liability will be imposed. The civil and criminal liability will be imposed. The management of the company is with the board of directors. That's it. And the company can have maximum number of 15 directors. However, a company may appoint more than 15 directors after passing the special resolution. That is important. That is important. Okay. Every listed public company shall have at least 1/3 total number of director as a independent director. As a independent director. The central government may prescribe minimum number of independent director in the case of the class of public company. So who will decide? The central government. Independent director that's not work under the control of any other person. The methodology to be adopted for the appointment of directors, rules of retirement of director is with the unit. Other provision of Company Act as regard holding of qualification share by directors, maximum number of directorship that is of 20. Party transactions, loan to director, etc. Everything is written in the Company Act. Okay, now let's start with the questions. True and false. Directors are the actual owner of the company. That is true and false. Directors are the actual owner of the company. That is true and false. That is false statement. Company has to be compulsory registered under the Company Act 2013. That is true. Just give me a quick reply. Company cannot enter into contract in its own name. That is absolutely false because company have a separate legal entity. So the company can enter into contract with its own name. Yes. If all the member of the company die, then the company will be wound up. That is absolutely no. The company will go as it is. Company is a legal person with perpetual succession. Every question you have to do. Okay, now, in the case of company limited by share, the creditor of the company can recover money from the member if the company is not making profit. Tell me, class. A company limited by share, the creditor of the company can recover money from the member of the company, can recover the money from the member if the company is not making profit. Why, Baba? This is absolutely false. Why? Because we know na company and the member have a separate legal existence. So with the fault of company, we cannot ask things from the member. Member cannot transfer share in a public company without consent of other. This is absolutely false. Why we need a consent? Guys, why we need a consent? No need to take the consent. We can easily transfer of share to the any person. Prospectus is generally issued by public limited company. Prospectus is issued by the public limited company. The answer is yes. Now, the minimum number of members in a private company. So the minimum number of members, minimum in a private company is 2. Minimum in public company is 7. Maximum in the private company is 200. Very simple questions are there. Maximum number in a public company is n number. The private company, minimum paid up capital, and public company, minimum paid up capital. What will be the answer? Tell me, class. This is important one. The answer will be no minimum requirement. No minimum requirement. In a government company, the government hold at least dash percentage of paid up capital. That is 51%. So I think from today's session, So as you can easily see that we are doing the questions and answer of your this one, Company Act. Okay, so I think we have done with the LLP, right? We have just done the summary of LLP. We have just done the questions of LLP also, and we also done the summary of the Company Act. Okay, and we have just done this question, this one, that's it. Okay, so now from next slide we have to do this thing now. So you have to tell me the true and false of the following question. See, in the case of conflict between Memorandum of Association and Article of Association clause, the Article of Association will prevail. Say yes or no. So for this question, you have to know that what is Memorandum of Association and what is Article of Association. So if there's a conflict, because Memorandum of Association is one of the most important document of the company, and Article of Association is also, right? But this is more important than this one. So the Article of Association will prevail. This is absolutely the false statement, because memorandum is important. Memorandum, see, this is your Company Act, this is MOA, and this is AOA. So AOA is always subsidiary to the MOA, right, and the Company Act, always. Okay, and memorandum is subsidiary only to the Company Act. So this is important from the examination point of view. That's it. Okay, next. One of the clauses contained in Memorandum of Association is known as Object Clause. So now let's understand the clauses of Memorandum of Association. Name clause, capital clause, liability clause, registered clause, registration clause, objective clause, and association clause. Association clause is also known as subscription clause. So that's why for B1, this is absolutely right. Right? The memorandum and article of company, once registered, it's bind the firm. Tell me. Bind means that they have to do the things which is written in the memorandum and article of association. So memorandum and article of a company, one register, it's bind the firm. The answer is not firm, but it's bind the company. Bind the company. So this is wrong. Because firm, we know that in the partnership firm, it may be registered or not registered. It is optional for the partnership firm to be registered and not registered. That's it. Okay, so this is the right answer. Done. Next. Doctrine of, see, 3 doctrines are there and the questions are there. Doctrine of ultra-vires, right? Doctrine of constructive notice and doctrine of indoor management. So what is written here in the first point, ultra-vires lay down that every outsider is assumed to have read the memorandum of association and article of association. That is the right point. So first of all, remember the points. For this thing, you have to know what is doctrine of ultra-vires, what is doctrine of constructive notice, and what is indoor management. That's it. So the doctrine of ultra-vires, that is basically, it means beyond the power. Beyond the power. That is called ultra-vires, right? So, but this sentence, that is every outsider is assumed to have read, this is known as constructive notice, because this is the definition of constructive notice, that whatever that is written in the ultra-vires. So that's why this is absolutely false. This is absolutely false, because ultra-vires means basically beyond the power. Suppose if the memorandum of association is there and the company go beyond the memorandum of association, beyond the memorandum, so that act will be ultra-vires. So what is ultra vires? Beyond the power, and that act will be called as the void one. Okay, next. Doctrine of constructive notice. So I have already told you this is the definition of constructive notice. Now see what is written here. Outsider are not required to see the compliance of internal management of the company. Class, this is the definition of indoor management, because constructive notice is this one. So this is also absolutely false. This is also absolutely false. Is that okay? Constructive notice. Right? And this is indoor management. Then class. Now, what is indoor management? Lay down, company cannot carry out the object not permitted by its memorandum. Class, this is the definition of ultra vires. This is the definition of ultra vires. So that is absolutely false. All the statements are false. So now please read the statement. This sentence is of constructive notice, this is of indoor management, and this is of your ultra vires. That's it. I think this point is clear to all of you. Right, guys? This point is clear. Okay. Done. Next. Again, true and false. A minor can be the member of private company, but not the public company. That is true and false. Tell me. A minor can be the member of this, but not the public company. That is absolutely false. The minor can also become the member of public company. That's Japan. A member can inspect the register of member. That is the statutory right of member. So the answer is absolutely true. In a company limited by share, right? It is a type of company. The member is liable to pay the full nominal value of the share, and the liability of the member ends there. So please remember the types of company. Tell me, class. The company limited by share. This is the right definition because we have read company limited by share, company limited by guarantee, and unlimited company. So these are the three types of company that we have read. So under C1, the right answer will be, that is absolutely false. True, that is true. A company is required to keep its foreign register in India only. Tell me, guys. A company is required to keep its foreign register in India only. Tell me. So here answer is absolutely false. It have to be kept in the India, not only in India. Okay, not only in India. Done. Now, there is no remedy available for the misstatement prospectus by the director. If any misstatement is there, so there is no remedy. And I think we have just read in the prospectus, if any misstatement is there, there is civil liability and there is criminal liability, right now. So no remedy available for misstatement of prospectus by director. That is a true statement. The answer is absolutely what? Answer is absolutely no. That is false. because the liabilities are there. A company proposing to issue red herring prospectus shall file it with registrar at least 3 days prior to the opening of subscription list and the offer. Yes, B point. A company proposing to issue the red herring prospectus shall file it with the registrar at least 3 days prior to the opening of the subscription list and offer. That is true and false. That is absolutely true. So you have to remember this point. You have to remember. Okay, next. Fill in the blanks from the options given in the bracket, right? The maximum number of directors in a private company can be 3, 7, 12, 15. Tell me, guys. Maximum number of directors in a private company. Maximum, that is 15. Maximum number of directors in a public company class. In a public company, that is also 15. Minimum number of directors in a public company. Minimum. So the minimum is always that is public 3. And minimum in private company, that is 2. At least dash of the total number of directors of a public company are to be the person whose period of office is liable to determination by retirement or rotation. This is very important question. This is very important question. Tell me, guys. The question is very simple. At least how many of the total number of directors of a public company are to be the person whose period of office is liable to determination by retirement or rotation? That is 2/3. You have to remember. Every public company, private company which is subsidiary to public company having a paid up share capital of rupees dash must have managing and whole time director and manager. Tell me, class. Every public company, private company which is subsidiary of a public company having paid up share capital of rupees dash must have a managing and a whole time director or manager. So the paid up capital we have already done, that is absolutely nil. This is the right answer. Is that okay? Additional directors are appointed by dash, whether it is board of director, promoters, underwriter, and the shareholder. So the additional directors are appointed by the board of directors. That's it. Alternate directors are appointed by, a very good question. Additional director, alternate directors are appointed by which person? Directors, promoters, underwriters, shareholders. So here in this point, the board of director is the right answer. Okay, board of director. Now, the last one. Casual vacancies in the board of director is filled by the dash, board of directors, promoters, underwriters, and the shareholders. What is the right answer? So this question also, that is a board of director. So this is all for today's class. So today we have done with the questions. Right, class? So these are the questions of your Company Act, and these questions we have already done this. Right? So if you are new in this session, so this is your video course. Right, guys? So video course in basically because you do not have a time to take the paid class. So that's why it's the time to please see the recorded session of the video courses, right? Second, whenever you will complete the recorded session, whatever questions I am giving in the session, you have to do the questions. Next thing, after questions, you have to focus on the mock paper of the BRBL subject. And do not miss to see the YT session in which we have done the module wise questions, we have done the definitions, and we have done the summary and questions. So this is very important from the examination point of view. Very important. Okay. And this is your CAIIB, what is prime test pack. In the CAIIB prime test pack, suppose if your concept is totally clear, so you can join the CAIIB prime test pack in which ABM, BFM, ABFM, BRBL subject is there, which contained almost 2000 questions. Okay, this is totally based on the new syllabus and pattern. So whenever you just complete your concept, focus on the questions. That is important. That is important. Okay, questions are very important. And this is your live classes. In the live classes also, recorded sessions will be there, mock paper is there, right? Everything is there. And this is your CAIIB ka Mahapack. If you purchase it today, in the CAIIB ka Mahapack, it's almost contained. CAIIB ka Mahapack is basically of your